All right. We are ready to go live as what Bill, what's his name from Fox News? We're going to do it live, is what he said. And I can't think of his name, and I shouldn't even be quoting something that I can't reference. So I'm sorry to kick off this podcast with a bummer. Eric, it's good seeing you. I want to give some people some time to join in here to the broadcast. So I'm going to cover a few housekeeping items, and then we'll dive into the news of the day. So before we do that, though, I want to welcome everyone to the show. Just so everybody is aware, we can see your comments. So if you're watching on YouTube or LinkedIn, please participate. This is obviously a topic that likely will have a lot of questions. I'll try my best to get through them all. But go ahead and write them in there, and we'll try to get to them. Also, we may not cover everything. We may, but we are going to cover this again at Lead Generation World, January 8th and 9th in Florida. We've got Eric and Pooja from the Troutman Amin firm that will be there. They've got their booth right next to the Troutman Amin stage, which will be covering this topic in detail. And so, listen, at the end of the day, this is a very, very important topic that we've been discussing for the last few months. Like I said, we're going to discuss it here today because of the big news that came down today. And then Lead Generation World is just an important event to kick off your 2024 to make sure you're directionally pointing it in the right way to be successful. So hopefully we'll see you there. We do have lead buyer passes for $150. So if you are a brand or a lead buyer, there's no real reason why you can't attend. It's extremely affordable. I know the pass is kind of expensive right now. If you waited till today to buy, the pass is pretty expensive. So I do have a discount code for you guys. And let me just put it up here. This will save you $400. $400. And I'm going to put it up here in just 1 second. And you can write that down and go register and make sure you're all set for 2024. So enough advertising. Let's get to the real deal. Eric Troutman from Troutman Amin from TCPA World, the czar, is with us again to tell us what the heck happened today, this December 13th, 2023.
Yeah. So what happened today was exactly what I told you was going to happen about a year ago. And Mike, for you have to get credit, man. You were one of the few voices in the industry, one of the few people that actually heard what the czar was saying. And we're like, wait a second, this is a big deal. And I remember going all the way back to January of last year. Like, you were literally the first guy that had me on your podcast. And you were like, everyone's saying Troutman's crazy, but I don't think he is. Like, there's something to this.
Let's not get carried away. I mean, and are a little crazy.
but you were the guy, Mike. I mean, you were the guy that first took it to the street and really kind of connected with your network on what I was trying to say on my network. So you get a lot of credit, man. You were right there from the beginning. So what the commission did was, kind of exactly what we saw coming, which is it has changed the rules completely for lead generators. Now, as we know today in the current environment, right, the lead generator, the kind of marketer that's in between the consumer and the ultimate good or service provider can use a website and can obtain consent from that consumer to receive calls from, marketing partners, a long list of people, hopefully who can provide the good or service that the consumer is actually interested in, right? And currently, people might have 5,000 people on those lists, although they're only supposed to sell, the data to maybe 5, 6, 7 different partners, depending on kind of what the deal is between the partner and the lead supplier. That's very, very common. But as we know, as I've talked about many, many times, and you guys know, I'm the president of Reach. We created the organization to shut down the bad conduct that's going on or has gone on historically in the lead generation industry. But because of some of the abuses, right, because of examples of consumers having their data sold, not 5 times, but literally hundreds of times, aged leads being sold years after the people are out of the market, after phone numbers even changed hands, just a lot of really bad stuff out there, even allegations of fraud. Because of all these abuses, the FCC had received a number of complaints, and ultimately this organization called the NCLC, that's the National Consumer Law Center, kind of took a look at what was going on in the lead generation industry and just basically told the FCC, hey, look, you need to shut this whole thing down. And the FCC came about this close to really just saying you can't even sell leads, but they didn't do that, thank goodness. What they did do, though, was say that in order for a consent to be valid, now the consumer has to opt in to receive notification from one and only one seller, and that means a good or service provider. We're going to talk about that here in a second. From one or only one good or service provider at a time. Now, there's a little bit of room here, right, where you could still have 4, 5, 6, maybe 10 people listed with check boxes where the consumer can click each one individually. And I've already seen people saying, can we do a select all button, blah, blah, blah. We'll talk about all that here in a second. But the bottom line is that consumer has to opt in one at a time to each ultimate good or service provider that is going to reach out to that consumer. And that's it. That's the rule. It's a 1-to-1 consent rule. It's very narrow. Additionally, right, that's a third party issue, right? Additionally, though, there's some first party issues here because now the calls have to be topically and logically related to the transaction where the consumer gave the consent to begin with. That is a bit of a departure from existing rules, right? Where if you go on to wellsfargo.com and provide your consent, Wells Fargo can contact you regarding multiple products or services that it offers. Now, after this new ruling, again, this is first party, right? Wells Fargo can no longer make outbound calls related to non-topically and logically related services. So if you come in for a deposit account, they can't call you probably, right? We got to find out what topically and logically means, but probably can't call you regarding student loans that they might offer. So that's a first party issue, right? So you've got third party issues, you got first party issues. This is a really big change. It's going to have like a lot of impact.
Okay, so one of the questions that I think a good starting point is this. It falls under TCPA, right?
Yes. So if I didn't say that, I guess I should clarify that this is a ruling impacting the scope of the Telephone Consumer Protection Act. That's the TCPA's express consent defense when you are making outbound calls using regulated technology.
Exactly. So does this all go away if you just pick up the phone manually?
Oh, Mike Free. Maybe. So this was the big loophole, right? That I was teasing on TCPAworld.com. For those of you that were at the big summit, we had the Reach After Dark meeting, and I would not talk about this publicly until the meeting today because I did not want any modification to this ruling. But yes, Mike, you are correct. If you are calling using either like literally a phone, where you're picking up the phone and you're calling, or you are using like a human selection tool like Safe Select, right, or Drip's Initiate product, you are correct. This ruling does not apply to callers who are not using auto dialers or pre-recorded voices. So if you are calling manually, true manual, remember these rules are very fuzzy around what's manual, what's not. But if you are calling true manual, then yes, you can continue to use those old leads, right? Like the current environment leads, even to numbers that are on the DNC list, right? And that's the key loophole that exists, ironically, within the order that was supposed to close the loophole. They actually opened up a loophole that wasn't there before, in my view. So that is interesting to me, and it should be interesting to folks that are listening. But anyone who is using regulated technology, including any form of pre-recorded voice, any form of AI outreach, and importantly, any form of an automated system, right? Because I know Facebook narrowed it, but as you've heard me say before on stage, Mike, these rules are very fuzzy, especially at the state level, but even at the federal level. So you have to understand this is a new paradigm, and you should be looking for leads that meet the new paradigm unless you are absolutely sure that you are calling using non-regulated, really manual technology.
Got it. Okay. That's important because following, and my guess is that at some point they'll close that as well, loophole. I mean, who knows?
We should put an asterisk there, right? Because first of all, the NCLC is already taking the position, as are 28 state AGs, right? This loophole isn't really a loophole. All right. And so people need to kind of understand, we're going to call it a loophole. I think it is, but there's going to be an asterisk there, because these entities are saying, no. If you read that section, right, which is a different section, it's not prior express written consent. It's a prior express invitation or permission, which is a different definition. And many courts before today had held that those two things meant the same thing. But after today, they are not going to mean the same thing, because the FCC changed one definition and left the other definition alone. So what the NCLC and the 28 state AGs are saying is that the definition of prior express invitation or permission actually requires one-to-one consent as written already. So now the FCC did not weigh in on that. And again, to date, no court has agreed with the FCC or the AGs on that issue. But those of you that are going to try to take advantage of this new loophole we were talking about, you need to recognize that you're going to get challenged by the plaintiff's bar, and they're going to say, no. Look, even though the modification was not made, even though the definition did not change, always it has been the case, right, that this secondary definition requires one-to-one consent, and that's critically important for a couple of reasons, and something everyone has to keep in mind, right? And again, I am hoping that this does not come to pass this way, and I don't think it should. But the ruling that the FCC just made on prior express written consent, that should be prospective only, meaning it should only apply in the future and not to past calls. However, if the loophole isn't really a loophole, if the NCLC is right and prior express invitation or permission has always required this to be one-to-one or direct between the consumer and the ultimate provider of the good or service, that's a real problem, because that's retroactive. And that means anyone who has relied on express written consent, obtained third party to make outbound calls to numbers on the DNC, have already violated the statute and has a 4-year look back. So that's a really bad issue. I'm hoping that doesn't happen, right? You heard me tell you this thing was going to happen. Now you hear me telling you this shouldn't happen, but it's not out of the question. All right. So it's something that everyone needs to pay attention to also.
Okay. All right. Let's get into sort of the technical details of what one-to-one consent may look like on a page and what that really means. So as you elaborated on earlier, or actually maybe it was your article that you posted today that's popping into my mind, as you wrote about how it was currently or before this, where a lead generator would have a bunch of different partners, and once they hit submit and they check the boxes and all that sort of stuff for consent, that lead would then get distributed to multiple lead buyers. Now that consent has to be on the form, and the consumer has to manually check, I would like Wells Fargo to call me. I would like this person. I would like, this company. Is there an order of that on the form that is, I want to ask a look, because I think there's been a lot of questions around the technical, like what's happening with the matching from a technical standpoint. Correct. So when I show, let's just talk about mortgage for an example. If I have somebody that tells me they're in California, they have a $500,000 loan, they want to refi, and I go, okay, great. Can I still continue to collect personal identifying information and then ping which companies may want that California refinance lead that's $500,000 and then show them that? Or is there an order? Does it matter? If I'm collecting personal PII information on the form, does it matter?
Yeah, so there's a couple of different pieces there. So anytime you start talking about PII, you're talking about some California consumer privacy issues. I'm going to put those aside. Okay, we're only talking TCPA today. Okay, so please understand there's other privacy issues, there's SIPA issues, but we're going to put those aside. We're only going to talk TCPA. When we're looking at this new rule, all right, so ping post is the current rule most of the time, both for warm transfers and for data, right? You go to market, you get the consumer's consent, and then boom, you're like, hey, who wants this based upon these criteria? And presumably the best qualified good or service provider who can best help that consumer based on those criteria is going to bid the most, and therefore they're going to get that lead, right? That's how it works today. When this first came out, I considered it to be the death of ping post completely, because there's no longer going to be the ability to go to market to find the lead buyer that best suits this consumer. The consumer has chosen who that lead buyer is going to be based upon who they selected on the form. But that's not entirely necessarily true, because as Travis Prouty and others have pointed out to me, well, what about pre-ping, right? They're going through the flow. They're selecting, they're entering information before you get to that last page where the consumer is presented with their list of options, essentially in terms of who they want to consent to. You could go to market, same auction process, and say, hey, look, I've got a consumer. These are their qualifications. They have not yet provided that express written consent, but are you willing to bid on that express written consent? Now, what's fascinating here, right, is that there's kind of two products for sale there, right? One product is the anticipation that the consumer will complete the flow and give you the express written consent. That's one thing you're bidding on. But the other thing you're bidding on, because nothing in this rule seems to prohibit this, is that data could still be transferred to the bidder, right, as a trigger sort of lead, but you just couldn't contact them using regulated technology like we're talking about until the consumer completes the flow, right? So this is what's kind of fascinating here. And this goes back to that second loophole that's kind of been opened up, right, is now this poor consumer who doesn't even know they've completed the form, hasn't even clicked the button yet. Let's say they go through the entire flow, right? This pre-ping process we just talked about takes place. I understand in current ping posts, right, the data is not transferred until the auction is completed. But you could imagine a new scenario now in the new world where maybe you're bidding, and when you pay, you get the right to have your name listed, but you're also paying for that data lead, like kind of as a trigger, which of course you can't call on because that's not consent, right? But it still is kind of it's definitely a marker that you might be able to utilize in other marketing efforts. So it's kind of fascinating that now there's going to be kind of a different market for consumer data than currently exists. But staying with the flow to express written consent, right? The pre-ping will take place. Presumably, let's say 3 people want to bid on that last page then that the consumer is presented. You're going to see those 3 names right there. I'm going to guess, I don't know, I'm going to guess that, in the marketplace, they're going to list based, number 1 will be the one that bid the most, right? Mm-hmm. Number 2, second most, 3, third most. I don't know this, but I assume that's the way it's going to work. And then there should be check boxes there, and the consumer has to be able to check which one the consumer wants to hear from. Already a lot of questions. Can the boxes be pre-checked? Can we have a select all button? How does this all work? We're going to do more details on this at the lead generation world. I would encourage everyone to go to this. We're going to have, it's going to be a groundbreaking show that we do, 45-minute segment, Pooja and I. We're going to really dive into this stuff, put up, pictures and architecture so that you can kind of see how it ought to work. For now, look, if you need legal advice, obviously call us and we can give you actual legal advice. But at a high level, right, you want to be conservative here, right? You do not want to be the knucklehead that's using a dark pattern that has the big select all button, and then like a little tiny, select different, select individually here. You don't want to be doing stupid
yeah,
stuff like that.
Yeah, that's not that would be smart. Yeah, and let's assume that it needs to be, clear and conspicuous. You have to clearly check one or all or whatever it may be. But I just want to kind of get back to the ping again, the ping post sort of technology, which is I've got a set of data that is not the person's phone number. I'm not sharing that at any point in time. I'm just sharing location filters, whatever it is that are appropriate for that lead or that vertical that someone can bid on. I send that to, can I send that to Jerry's Legion shop that has a relationship with Wells Fargo? And Wells Fargo then sends, then it goes through Jerry to me. Can that happen?
Yes. And I'm glad that you brought this up, right? So this is the second piece, right? Because when one-to-one first came out, my first thought was, oh my God, the networks are dead, right? The brokers are dead, right? The individual publishers are dead because the individual publishers don't have relationships with Wells Fargo, right?
Right.
And I just thought, wow, this is really, really bad. But then if you sit back and you kind of digest the rule, it is very stark on the one hand that Wells Fargo's name has to be on that form, right? And not just on the form, but the consumer has to specifically say, I want to hear from Wells Fargo. But the challenge is not as daunting as it initially struck me as, because nothing in this rule prohibits that in-between broker, right? Okay. So Wells Fargo doesn't have a relationship with Bob in his parents' basement who's generating a lead based on, some financial blog that the guy did. But Wells Fargo does have a relationship with, big unnamed company X, right? Who has 10,000 publishers in its network. And so long as that network provider, that publisher is selling to the network, and then the network sells to Wells Fargo, as long as that consumer's data goes one, boom, right, you're fine, which is good for networks because now they're still alive. It's still good for publishers, less leads in the ecosystem, but maybe the same number of publishers. We'll see. But it's actually bad for Wells Fargo because now, as you can imagine, right, Wells Fargo is going to be paying a little bit more, but you know that publisher might be part of multiple networks, right? And that publisher might sell it to network 1, network 2, network 3. All 3 of those networks only have one place to go with that lead: Wells Fargo. No one else can buy it, only Wells Fargo. So Wells Fargo's got to be on guard here because they're going to get this lead from the same URL 3, 4, 5, maybe 10 times because that same URL, that publisher is going to sell it to multiple networks, and those networks are all going to be trying to sell it right back to Wells Fargo.
Yeah, that's a tech fix though. That shouldn't occur. In a dedupe opportunity, and if Wells Fargo, if there's multiple bids coming, they could be outbidding each other. There's some scenarios there that could. You
see the pressure, right? The networks are now under, right, to be the first to market to Wells Fargo. It's really fascinating, kind of the way this is going to play out. It's a totally new world. It's really interesting.
Yeah. So I think this is important though. So a publisher can have a relationship with multiple aggregators, let's call them, and lead generators. Sure. That have relationship with brands. They don't have to have that one-to-one relationship. So that's clear as of right now. They can have multiple options up on the page that they just have to check. Now, does I read somewhere at some point in time that the disclaimer text needed to be unique or had to be associated with Wells Fargo. Now, help me understand that. Does that mean it has to come from Wells Fargo, or does that mean it just means, hey, by the disclaimer on the page has to say, by checking these boxes that are shown to you here, can it be a general statement that all the disclaimers, one disclaimer, not one for each company, right?
So it can have one general disclaimer.
Okay.
As the rule is currently written, I'm going to put an asterisk here because this is important. There have been changes to the proposed rule that we have not yet seen. The FCC, both Commissioner Carr and Commissioner Gomez, during their remarks today, both said, we had edits and thank you for making the edits. So there are edits to this rule. We don't believe it changes substantively the rule, but these are the kinds of details that might change. Okay, so we're going to put a little asterisk here because we don't know necessarily for sure. But as it is currently written, as it was proposed, as it was voted on, as far as we know, recognizing there might be some small edits here, the only requirement is that the disclosure, and of course it has to have the full Troutman 9 or the Amin 14, as people are starting to call it now. That has to be it has to come first. I don't know why, but that is the rule as written, is it has to come first. So you're going to have, your phone number field, right? Or whatever the data entry fields are. You're going to have now the disclosure, nice, clear, all the different points, right? And then beneath the disclosure will be the check boxes for the different companies. You do not have to have the same disclosure over and over and over again for each company. And then the button, though, has to be below all those options, right? So all that has to be above the button. That is all laid out in the proposed ruling or in the ruling that was proposed. Again, we have not seen the final, but I'm anticipating that most of that, if not all of that, will be preserved.
Got it. Okay, so you mentioned this is part of TCPA, which is, how would you say, policed by the plaintiff's bar?
That is correct.
So how are both lead generators and lead buyers going to protect themselves from potential, ambulance chasers?
Well, you got to know the rules, man. It's as simple.
Well, what I mean by that is what information needs to be stored and kept so that if someone were to say, hey, it looks like you called me from a auto dialer and I did not, I don't even know what the argument was going to be because I feel like it's going to be pretty clear. But what do lead buyers and lead generators need to store, and what are they responsible for to prove their innocence in a case?
Yeah, it's a great question, especially because this new ruling actually changes the record keeping requirements, right? So today, right, if you are a caller, right, you need to make your outbound call based upon a valid express written consent, right? That express written consent, again, it has to have the Troutman 9 or the Amin 14, like it has to have all those requirements. The CFR has to be black and white in writing, but you as the caller don't actually have to be in possession of that record, right? You can get the data ping through an API, make the outbound call, speed to lead right away without ever actually having the consumer record in your hands. That's going to change. The FCC says, as part of this ruling, that no, the caller cannot rely on the third party to hold onto the consent record for it. The caller has to take possession of the consent record before that call is placed. Now, we were at the TCPA summit and we were talking through, like, how do you do that, right? Like, what is the mechanism by which a caller takes into physical possession a consent record which took place online, right? I mean, it's not like you're going to be able to.
Well, what is consent record? And when you're using that, what is the consent record?
The consent record is the record of the event that took place, right, on the website where the consumer sees the valid, hopefully, again, has to have the valid language. And then presses the hopefully valid button that says, I accept terms, or I accept, whatever this says above, right? And, again, in today's world, that stays with, generally speaking, with the lead seller. In the future, companies like Trusted Form, right, or Active Prospects, Trusted Form, or Jernaya, those guys just made $1 billion. I wanna just go and buy a bunch of stock in them because as far as my little brain can figure this out, the only way that the caller can actually take into possession the consent record is to claim the certificate, claim the actual form, and download into their system from Active Prospect, from Jernaya, these third-party witness attestation programs, into their physical servers at the caller's location, the data, for this event that took place.
Yeah, I'm a little confused about what that record is. Like, is it a IP? Is it a timestamp? Is it an IP address? Is it a couple different things? Is it an active prospect code? What?
I think it would be the visual rendering playback along with all associated consumer input data. I mean, that's to me, that's what I'm thinking, right?
Okay.
I mean, so if you zoom out and you look at it from the highest level, like when you're in court, how do you prove consent? Right. Well, you prove consent if the consumer admits that they went on the website. You prove consent with a declaration from the website provider that this was the visual that was on the display at the time that a consumer using this browser would have reviewed at that exact moment. And here is the IP address and the web session details and all the inner consumer details that we have. Right. But the problem is that lead suppliers are not going to be giving you a declaration every time they send a lead to you, right? Yeah. So you're not going to have that. That's not going to be the record, which would be the best evidence. That's the best evidence, right, of what happened is literally the attestation from the lead supplier. But that's not going to happen. And if you have a lead supplier that will do that for you, great. But as I look at this from a practical perspective, the second best record, and the record I think is going to be the marketplace standard, is your Trusted Form, which has the visual rendering of the consumer going on to the website, right? Moving the little mouse around, entering the information, clicking the button, substantiating what form of disclosure consent was present. And in the new world, hopefully all the check boxes being individually checked and approved, right? That is going to be your record of consent. But you can't just take the token. You're going to actually have to go claim the form, download it, put it onto your system, and have it physically ready to go before you make that outbound call.
Okay, that sounds crazy.
It's nuts, but that's what the FCC just said. And by the way, the FCC made that portion of its ruling without any comment at all. And this is, I told you so in a bunch of things. This one I didn't see coming either. Nobody tipped me on this. I don't even think that the commission realized what it just did. It just kind of slipped this in.
Yeah. Is that just your definition or your guess of what that means? Or could it be as simple as just a timestamp and an IP address and a domain address, a URL that goes along, that gets sent with it and goes, hey, listen, I've got their IP, I've got the timestamp, I've got the URL. I don't need a screen recording all this other that's sounds crazy to me. But so that's the best case? I know that's what, if you could get that, of course, that's a wonderful. But Do you think there's some, interpretation there?
Yes. No, I mean, look, I should say none of this is known for sure.
Okay.
None of it, right? All of this will be in the court. I'll just read it to you, right? This is literally what the ruling says. We take this opportunity to reiterate that the burden is on the texter or caller to prove that they have consent that satisfies the TCPA and our rules.
Okay.
They may not, for example, rely on comparison websites or other types of lead generators to retain proof of consent for calls the seller makes. In all cases, right, that caller has to have that consent in their records. So to your point, maybe it's just a line of data, right? Maybe that's all you need. Maybe. Yeah. And don't get me wrong, if I have to defend that in court, I'll take that position. I don't think that that's a laughable position. I don't think anyone's going to say, "Oh, Mike, you're crazy." I don't think so. I think that that's a good faith position, but I don't think that that's what the FCC means. To be perfectly frank with you, I think they're looking for a more fulsome record, and I anticipate that at least some courts are going to require a more fulsome record.
Okay. So before we go, there's a lot of questions that are all over the place that we're going to dive into in just a second. And want to give a lot of time for those. But I do want to sort of wrap up my questions with, do you suspect any challenges to this ruling to take place in the next 36, whatever time, near time frame, that for those companies that participated in the comments and all that sort of stuff? Do you suspect there'll be any challenges for this?
It's a great question. So I'm already hearing that like a bunch of companies that don't have standing are like, "Oh, we're going to go challenge it," and I'm just rolling my eyes because you're just wasting money. Beware. Let me start with this.
You have to participate in the comments, right, to be able to challenge it, right?
Right. So, well, let me say this.
Okay.
Beware of any lawyer that tells you that you can challenge this ruling if you didn't participate in the NPRM proceeding with a comment, at least a comment, right? If you didn't at least make a comment, you don't have standing. Like, you cannot challenge this ruling in court. Now, you can do other things, right? But you cannot challenge this ruling in court. So the companies that or the entities that definitely have standing are CTIA, Lending Tree, Net Number, and of course Reach, right? Which is Responsible Enterprises Against Consumer Harassment, which is the big trade organization for the lead generation industry. So that seems to me to be the enterprise that's most likely to be the vehicle here. There's other entities, 3 other entities that probably have standing as well. That's the Insurance Marketing Coalition, Quinn Street, and the Solar Energy Industries Association. There are 23 others who participated in some form or fashion in the proceeding that may or may not. And unfortunately, the case law here is vague in terms of like what it means to have standing. You have to be a party. You have to have participated. You have to have fully, that's the word, fully participated and had your views shared. So what does that mean exactly, right? Reach, for instance, we commented, we commented, we had 6 meetings with the commission, we had 6 ex parties, like we participated, right? Lending Tree, very similar situation. Quinn Street to a lesser degree, but they also, I think, pretty clearly participated fully. These other entities, they made like 1 comment, 1 reply. So it's not clear, is that sufficient? We're gonna have to find out. But the answer in terms of, is anyone going to challenge this? So that's a great question, right? Obviously, I've not talked with Lending Tree. I've not talked with Quinn Street. I don't know where others are going to land here. I can tell you, Reach has not yet voted on whether or not it intends to challenge. It has standing to do so. It very well may. What I've told the board, right, as the president, is go on a listening tour, talk to people in the industry. If people are willing to back it monetarily, because this is going to cost some money, right? It's not like this is free. If you're willing to back it monetarily and you believe that this is really something that the industry ought to do, then I think that Reach's board wants to be responsible and act on behalf of the industry as a whole, and would take a challenge. And by the way, there are definitely grounds to challenge this, so we can talk about that too. But on the other hand, right, as you know, Mike, Reach's mission is to stop unwanted calls. And directionally, this ruling moves there, right? It's not what we wanted to see. We don't think it's the right way to go. And I think, one could legitimately argue, is it going to work at all? But at least it's a step toward a cleaner ecosystem. And so it does align with Reach's mission. So I would say definitively, it is not like Reach is definitely going to go out there and challenge this. We might, and we're going to on a listening tour. We want to hear from people, and if people really want it done and are willing to back it, it could happen. But I don't think it's a foregone conclusion. I will say one other point as we're talking about this, and I've kicked this around with others. This even if we challenge this in court, and it's a very valid challenge, and there are very valid grounds, as Commissioner Symington correctly pointed out today in his remarks that in opposition to the ruling, then there are valid grounds here. But understand, it's going to take at least a year, 18 months, 2 years, right, for the appellate court to eventually overrule this. It is possible that lower courts will stay proceedings waiting for the appellate court, but there's no guarantee of that. And in the meantime, what's going to happen in the marketplace, right? You're going to have to adapt. You're going to have to innovate. You're going to have to change. And so by the time this ruling comes out, 6 months, a year, 18 months after the effective date, the market's going to have moved on.
By then. Yeah. So, I mean, okay, well, that's good. And I'm like, I think it personally, this isn't my opinion show, so I'm not going to give it, but or at least dwell on it. I think this is good. I think it's good. I think there needs to be a little bit more transparency in where things are going. So I think it's good for the consumer. I think it's good for lead generators. I think it's good, all around to some extent. So I'll leave it at that. But let's go on to some of these questions. Mandy's asking about TransUnion leads, so trigger leads. Does this ruling take into account trigger leads? Which I'm so surprised that trigger leads are still a thing, to be honest with you.
So look, the short answer to the question is this ruling does not impact trigger leads at all. Right? How? If they were legal before, they're still legal. If they were illegal before, which they probably are, in my opinion, they're still illegal. Okay. Now, remember, a trigger lead is just a data point. It's just something to alert you that someone may or may not be in the market. It is not consent. It was never consent before. It's not consent now. As far as I know, no one claims it's consent. And so it wasn't consent before, and it's still not consent. It's never consent. The question is, can you even take a trigger lead? Is that even a permissible use under FCRA? People will throw rocks at me because, the big CRAs have been out there promoting this as if it's legal. Never giving you any indemnity if it turns out to be illegal, never giving you anything in writing that says it's legal, right? But out there promoting it as if it is. My view has always been it's not. But that's just my personal view. My personal view.
So no change in trigger leads, basically.
No change. This NPRM does not impact trigger leads.
Interesting. Very interesting. Okay. What about warm transfers? We haven't talked about these. And so now we have generally a warm transfer funnel, which is a data lead, then a third party calls it on behalf of some buyers or what we call sellers now. But what's the how about we just turn this whole industry upside down?
Correct.
Yeah,
correct. It's something people need to wrap their head around, the new nomenclature, like right now. That's one of the things that is most confusing to people out there, and something we're going to really look at lead generation world. The term seller, right? When we think of seller in lead generation world, we think about a lead seller. Nope. That's not the way the FCC looks at it. And you have to stop thinking about it that way. The term seller is the brand. It is the lead buyer, which is very confusing to folks in this ecosystem, but it is not confusing to the FCC. They are very flipping clear on this. Okay. So warm transfers are impacted in two ways. One form of warm transfer is going to continue to be just fine, right? Which is where data lead comes in to the brand. Let's pick on Wells Fargo again, right? But Wells Fargo works with, call center X that maybe is a BPO, but maybe they're not a BPO, right? Maybe they're a third-party marketer, but they have a contract with Wells Fargo. And when they get a data lead that they are buying from publisher Y or from aggregator Z, whoever, it has to say Wells Fargo and just Wells Fargo. That consumer has to have clicked Wells Fargo, right? But Wells Fargo does not have to immediately ingest that lead if it doesn't have, the bandwidth to do so. It can rely on third parties who then will make those outbound calls to get that lead on the phone, further qualify, and do that warm transfer, right? When that third party is calling, though, they are calling on behalf of Wells Fargo, right? Mm-hmm. They are literally the third party arm, but the arm of Wells Fargo that is making that outbound call. That is fine under the new rules as I read them. Again, not legal advice. It's got to develop, but that's my take, and I think that that's right. Okay. Now, So that's going to be okay. What is not going to be okay, and this is absolutely critical for people because I'm hearing this repeatedly. I'm the seller, right? Says the marketing call center. I'm the seller. I'm selling the lead. I'm one company. I just want to put my own company's name on the form. If the consumer opts in to hearing from lead aggregator caller, number 227, why can't I call, get the consumer on the phone and say, are you interested in hearing about financing options from 5 different lenders? Yes, great. Let me sell this transfer now, right, to my number 1, and let me sell your data to the other 4, right? No, that is not legal, guys. Like, I cannot emphasize this enough, and I've heard it so many times. Again, this is my hot take. It's not legal advice necessarily, but I got to tell you, you are really going to get yourself in trouble if you, as a call center who is not providing a good or service directly to the consumer, lists your name, calls the consumer because they consented to you calling, and then sell somebody else's product. Like, I am telling you, that is not legal because the word seller does not refer to a lead seller. It refers to the entity singular, by the way, entity singular that is providing the good or service to the consumer that the consumer is actually interested in the first instance. So really critical. Now there's a little tiny, maybe smidgen of room for brokers, like true brokers who are selling like finding fee services to a consumer. Like, you don't know your way around financing. We do. We're experts to help you find the right financing for you. Maybe in that instance, you can call on your own behalf, get them to sign up for your service, which, by the way, the consumer would actually have to sign up for your service. And then once they're signed up for your service, then you can make additional outbound calls and or continue on that call to sell other people, right? So basically, your website says, come to me because I'm a great finder of services for you. They sign up for that service of finding other services, and then you go through and sell, right, these other products that the consumer is actually after. And that is like a big maybe. But I see a lot of people like trying to like go that direction. I'm not going to slam that door and say it's shut, but what is shut is the idea that you're just going to have the consumer call you, and then you're just going to pitch them a bunch of things as if that's the way the world works today. That's just not going to happen in the future.
Right. So you can't. Well, it's a non-starter because you can't put, if you're a marketing agency, the brand that they're opting into calling, or you can't do that. That's what you're saying? So
well, you could put the brand. Yeah.
Let's just use Lead Generation World. I'm on a form for insurance, let's say, and I'm one of the companies that can call you, Lead Generation World. And you opt in and go, Lead Generation World is going to call me. And then I pick up the phone, I call you, hey, Eric, we're actually a service that connects you with other insurance providers. We're not an insurance provider, but we have a partner with XYZ Insurance. Would you like me to transfer them to XYZ Insurance? And you go, yes. Can I transfer that to them?
No, you cannot. Absolutely not. So like, for instance, if you're Lead Generation World and you've got relationships with Geico, Progressive, Allstate, you're like, hey, would you like to hear from Geico, Progressive, and Allstate? But Geico and Progressive and Allstate were not on the form, right? The consumer did not agree to hear from those people.
Okay.
Then the answer is no. You can't.
The answer is no. So consent is not transferred at any point. I can't get new consent from a consumer to get to sort of re-up the consent for another brand at any point.
Well, I mean, I'll put a bit of an asterisk there, but you can't do it the way you just described. No.
Okay.
That cannot be done.
Okay. All right. That's interesting. So the only way a transfer is going to happen is if I'm a third party representing a single brand, and I'm basically providing call center services on their behalf.
Right. That's exactly right. Yep.
Okay. All right. That's interesting. Since we're talking about Wells Fargo, this was an interesting comment here. They have a ton of business entities. What are they what is the consumer opting into, to be honest?
That's the key, man. And this is the big first party issue, right?
Yeah.
The third party issues I think are pretty obvious for the eye to see, but I'll tell you, most of the big brands that are asking me questions right now, they're not concerned about third party. They're concerned about first party, because the way the reg is written, no, the consumer does not opt into the brand. They opt into calls from an entity. This is entity level. And so, if Wells Fargo's, deposit accounts are actually provided by Wells Fargo Bank NA, and Wells Fargo's financial services are provided by Wells Fargo Financial LLC, right? The consent to one is not consent to the other under this new rule. And that's a big change because that's not the way it worked before, right? Before it was you consent to receive calls from Wells Fargo and its affiliates and friends and pals and, all corporate subsidiaries. And that was just fine. Every court to look at that's been like, yeah, no problem. But the FCC, for some reason, just said, nope, not going to allow that anymore. It has to be at the entity level. Again, there's no way the FCC was thinking this through. There's no way. And nobody commented on this. Like Wells Fargo didn't come and comment on this. Nobody commented on this issue. And so, here we are.
And so I think you answered this question. So in your opinion, if a lead was from a mortgage publisher, but, posted to a student loan ping post, and the final consent is obtained 1-to-1, will that be protected? I think the answer is no, because it's not the on topic.
Well, it's a slightly different issue. So this is not, necessarily the first party subsidiary issue. This is now the topically and logically related issue. Yeah. And so this is a good question, right? It's mortgage versus student loan. Now, at the highest level of abstraction, you could say, oh, they're both lending products, right? Yeah. So they're topically and logically related. And look, some of this is going to be in the eye of the beholder. And it wouldn't shock me if some, Federalist Society judge somewhere out there agreed with that statement. But I think most judges, it's going to be common sense. If you're looking for a mortgage, you're not looking for a student loan, right? You're looking for a mortgage. So now maybe, there's gray where you're looking for a 30-year fixed, but they're going to offer you, a 15-year fixed, or maybe they're going to offer you a 2-in-1 arm or whatever these things are, but it's still a mortgage product, right? Now, is that topically and logically related? To me, the answer is yes. It's not the exact offer the consumer was looking at, but it's still the product, and maybe the consumer doesn't qualify for the product that they thought they qualified for. So, to me, there's gray area there. But if you're looking for mortgages and you get sold student loans, to me, that's not going to pass muster. Again, some courts might disagree, but and I know it's frustrating because this is an eye of the beholder test, right? This is not black and white, and the commission knows that. The FCC basically said, we understand that this is fuzzy and no one knows what it really means, but deal with it. And that's one of the potential grounds, I think, to challenge the ruling if anyone wants to.
Okay. To be clear, one lead to one agent within logical and topical. Yes. It has to be one lead to one agent. I'm not sure I understand what that means. I think Francisco's an insurance agent. So the lead, I'm guessing I'd have to.
Well, so in the insurance scenario, so let's unpackage this a little bit, right? Yeah. Because it's actually interesting. It's actually interesting the way this plays out. So let's say you're Allstate, right? And you've got 10,000 independent agents, some who are captive and some who are not captive, right? If the form says Allstate and all of these entities are just serving as agents, right? But really Allstate is ultimately the seller, right? The one who's providing the good or service. Like who's providing the service? The insurance service? Allstate is, right? So if Allstate's name is on the form, the consumer opts in to hear from Allstate, I believe that all of its independent folks can still call on that lead because Allstate is the seller, and not all of the independent callers need to be named, just the seller needs to be named. So there's still room in the insurance vertical, and as an example, I don't believe, and again, not legal advice, it's got to play out. I don't believe each independent agency or agent is going to have to be named on the form. Now, in the franchise model, that's a different story, because in the franchise model, the mothership, the franchisor, is not actually providing any good or service, right? It is the actual franchisee that is providing the good or service. So, as I was picking on Keller Williams and Coldwell Banker, right? These big real estate companies that are brands, but they're actually using a franchise model, right? When you go buy a house, like Keller Williams isn't doing anything for you. It's Keller Williams broker number 227 in Delaware or whatever it is, right? So in that scenario, in the franchise model, it's the opposite result. The seller is actually the franchise. It's the little name, and that name has to be on the form. If it just said Keller Williams is not the seller. They are not providing you a good or a service. This specific franchise is. So they have to be named, right? So it's a different result, I believe, in a franchise model versus that more typical agency model. But again, all this has to play out in court, right? If you want to be safe, be as safe as you can, then get your specific entity, right, named on that form before you rely on a lead.
Okay. Back to transfers. What if the consumer calls a phone number on a landing page? So I am lead generation world again, and I'm a marketer, and I have got the form, and then also have an 888 number that they can call into to get information about insurance quotes. Of course, not for me because I'm not an insurer. So they're going to call me, and I go, "Hey, Eric, I can transfer over to XYZ insurance company if you'd like, and I can also take your information and send it to these other two if you would like. Can I do that?"
Yeah. So this ruling, I think, is very positive for companies that generate inbound leads, like real inbound leads, not, outbound to inbound garbage, like real inbound leads, call to actions on a website, organic search that brings you to a nice lander, consumer interacting with that, sees a nice offer, call to action they want to participate in, clicks a button to launch a call, or picks up the phone and calls in. That's great because this rule does not impact inbound leads at all, right? So that agent can do exactly what you described, or that broker can do exactly what you described, Mike. They can get data, they can transfer data, they can transfer the call. Now, what can't happen, of course, is the brand that then takes on that lead. They can't call back because they don't have express written consent, but they can ingest, right? And then they can contact that consumer in other ways.
Okay. Joey's got an idea here on warm transfers. This is obviously an interesting. Warm transfers is a big portion of calls in a number of industries, and so and a lot of those warm transfers were individuals calling on age data or whatever it may be, and then turning them into call transfers. I presume that's pretty much dead now with this ruling. But putting that aside, here Joey says you can call on behalf of your DBA, your lead generator, and then match them to a buyer in real time and text the consumer for opt-in proof of a seller or brand, then warm transfer them? ?
No, because the call was still originally made, right, to sell the product or service of that third party that wasn't on the original lead form. So you can't create the consent after the fact, right? That seller's name has to be on the form to begin with, is my view. Like, other people might disagree and be more willing to take a risk. I would not recommend that, and I think you're going to go down in flames. That's very similar to the current, like the pill pack ruling, right, where people are using a similar model, and there's a few companies I know of that are in trouble where their name was not on like the marketing form, right? The name of the caller was on the marketing form, but not the name of the seller wasn't on the marketing form. And there's the same scenario, right? You get them on the phone, you warm them up. Oh, are you interested in X, Y, or Z? They say yes, you transfer, right? And that's already in the current environment, leading to a bunch of trouble. So I would not recommend it in the future environment. Again, some courts might say that's just fine because you do have that intermediary step of the consumer providing that text message opt-in. I would imagine some courts are going to say that that's valuable. But I just think that's really high risk. Again, the risk is on the original outbound call, not the subsequent calls that are made by the sellers. The original outbound call that will lead to the class action.
Got it. Okay, so I think we got the answer to this early, but I want to touch on it here quick. Can a single form have multiple sellers on it, and the person checks 3 or 4? Of course, yes, they can do that as long as they're checking the box and clicking each one manually. Correct?
Yep, completely agree. That is correct.
All right, cool. So at the end of the day, lead generators need to use some persuasive copy to encourage individuals to select more than one, because that encourages a good shopping experience, and price comparison is healthy, and that's how you get the lowest price. So that just needs that sort of marketing speak needs to be on these websites, and we can't assume that someone's just going to pick 1 or 2, but there has to be, I think, probably something there that says, hey, here are 4 or 5 that you can choose from. We suggest picking at least 2 or 3 to compare. Yeah. All right, let's see. Let's move on. Let's see here. Let me find another one. Okay, here we go. Bill Rice, what precludes brokers and lead providers from just recategorizing internet leads as consumer data or intent data, in effect making it a trigger lead?
Nothing. I mean, nothing. That to me, that's like we talked about earlier. That's one of the unforeseen consequences of this ruling is, leads that aren't going to have a home in the new market as express written consent are still going to have a home, presumably for they're going to be cheaper, but they're still perfectly valid trigger leads, and maybe they're good quality trigger leads. Again, it's not express written consent, right? All the FCC ruling did was alter the dynamics of express written consent and TCPA. When you're looking at a pure trigger lead or intent lead, right, you are not using that lead for consent. You either have your own form of consent that pre-existed, or you're going to market to that consumer in a way that does not require consent. So, I mean, there is still value to the old school leads, but it's just not express written consent anymore.
We still got a lot of clarifying questions and stuff regarding warm transfers here. But the first, I just want to let everyone know that this is recorded, in that as soon as we end, it will live on LinkedIn and YouTube forever. So you can come back to this link at any point in time and watch us all over again if you so dare. Okay, so if a lead seller, I think we talked about this, but I think it's important we hammer it home. Can you do a warm transfer for 5 buyers that are listed in and captured 1-to-1 consent? Need to clarify that?
Yeah, in theory, the answer is yes, right? If you have relationships with all 5 of the lead buyers that are on the form, and they've agreed that the lead buyer has agreed that you're going to be their arm to warm them up, make the outbound call, get them on the line, and then warm transfer, like that's your deal with them, then that's fine, right? Because you are calling now on behalf of each of these individual sellers. Again, these are sellers, not buyers. Okay, the sellers who have given you permission to basically call on their behalf, and the consumer has agreed to receive calls from the seller. Now, I should say these forms should mention, right? You agree to receive, you're going to receive calls from seller and those calling on their behalf, right? That should be on the form, and that's okay.
Hey, this is enlightening right here, because this now changes what I was thinking earlier to some extent. So you're saying that as a lead generator, I've got relationships with my brands. Mm-hmm. They in the disclaimer consent says you're going to get a phone call from Lead Generation World on behalf of the companies that you select below.
Yeah, totally fine.
Okay, let me think
but
about
only
this.
On behalf of those companies, right? You can't get them on the phone and try to sell them somebody else. And if the consumer only checks 1 box out of 5, you can't sell them the other 4. It's just that one.
Yeah. Okay, I get it. Yeah, so it didn't really change much of what I was thinking, to be honest. Okay. Regarding warm transfers, let's see what Steve has to say here. Our friend over at Active Prospect, that according to you is going to be a billionaire. Steve, gosh, I knew we were friends for a good reason. You are going to be rich one day, according to Eric. So congratulations on that. Regarding warm transfers, what if the caller is offering a matching service to the consumer? That's a good question. Their role is to match the consumer with 1 or more brands. Right.
And so this is like the pivot that a lot of companies are looking at, and we got to be real careful here. Okay. Again, I cannot give you legal advice on this. All I can tell you is I personally believe there is an avenue for this, but it is like angels dancing on the head of a pin. And you've got to make sure that you are really, really cautious. Again, the website copy in this scenario would have to clearly say, we are a finder service. We are experts to help locate good companies that can provide the goods or services that you need, right? The call to action is to come to someone that can help guide you through a finance project or whatever it is, right? And the consumer has to actually sign up for that before you start selling them something else, i.e. the ultimate good or service that you're selling. Again, I think that there is an avenue for that. It would have to be really carefully built. The creatives would have to be carefully built. The funnel would have to be carefully built. I do think it's possible. That would not be my recommendation, though, right? If I'm a lead buyer, and many of my clients are lead buyers, I'd be cautious, approaching such a model.
Okay. Do you have 5 minutes? Can we do 2 more questions and just make them really quick?
Let me see. I got another call that starts right now, but keep going, and we'll go.
So relative to fraud, because this is a good question. If someone does information is submitted in a form and it wasn't really them, it was fraud by some bad actor out there that goes onto the form, goes to you, gets opted in, you call. How's the court going to look at that? Are you? Oh
yeah, you lose.
You lose.
Yeah, a caller is always responsible for fraud. And that's one of the big risks in the ecosystem. That's why I always talk about NURA and fraud detection. That's why that's a requirement of the REACH standards is you as a caller are always liable for that.
Okay, that's short answer. This is a fire round here. Last one here. This goes back to the Allstate example. An insurance that's actually brokering insurance from multiple different carriers.
Right. Very tough.
They still are just getting consent for here. This is JC's insurance, and because he's the one that's going to be calling and selling insurance, of course, to potentially other broker, or he's the broker.
Right. So in the broker model now, and this is really tough, right? I feel bad for the insurance brokers. They've got the toughest job because if the form says Allstate, well, they can then sell Allstate, but you're a broker, right? You've got duties to the consumer to provide the best insurance product, not just the one insurance product. And yet, if you start selling other products, you've now exceeded the FCC's rule that says you can only talk about that one product. That is tough, right? So it's almost as if the broker has to have its own name on there just as the broker, and the consumer has to agree to receive broker services in the first and final instance. I mean, that's a really challenging one. And again, it's not something the FCC thought through. I can virtually guarantee it.
Yeah.
But that puts the brokers in a tough spot.
Okay. So listen, guys, Eric's going to be there, Lead Generation World, the Seminole Hard Rock Hotel in Hollywood, Florida. We're going to be discussing this all day long, every day at Lead Generation World. So come, there's a discount code there. Eric, thank you so much for being willing to come on and just talk, give your opinions and thoughts about this stuff. We really, really appreciate it. I certainly do. And I know everybody listening in does as well. So thank you.
No, thank you, man. Again, like I said, you're a credit to the industry. You brought this to them first, and you deserve credit for that. So good job, man.
I appreciate that. All right, everyone. Thank you for joining. And we'll see you at Lead Generation World in Florida. All right. Cheers, Eric. Bye.